first case to come before us is Kobe Brown et al. V. Catherine Pannell. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes, and if you do plan to reserve time, please let me know, as I will be keeping track of time. The arguments are being recorded, so please keep your voices up. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. And the judges have read the briefs and are ready to proceed when you are. Would you like to reserve time for rebuttal?
Yes, Your Honor.
And how much time would you like to reserve?
About 5 minutes.
Okay, we are ready to proceed when you are, so.
Good morning. I am Charles Tyler Sr., and I represent the appellant, Catherine Pannell, in this matter. This is a case about a land petition. As you said, you already read the brief, so I won't bore you trying to go through all those facts. Going straight to my first assignment of error, it is the belief of the appellant that the trial court lacked the authority to make an award of attorney fees under RC 5307.25, an action for petition. A trial court is not permitted to make an award of attorney fees. Under RC 5307.25, unless the services rendered by counsel seeking the fees were rendered for the common benefit of all parties. RC 5307.25 requires attorney fees occur in action. In this particular case, there was no testimony or evidence to suggest that that happened. So it's our position that the attorney fees award was inappropriate. Even looking at the judge's order, she does not put in the order that such finding was made, and she made that attorney fee finding, and we believe that was error. Our second assignment of error, the trial court abused discretion when it awarded attorney fees requested by appellee without requiring evidence of the actual search performed by the appellee's counsel. Again, the witness on the stand was asked, what is this? She says, this is our legal bills, but there was no evidence or suggestion to show that they were reasonable, that they were actually billed, that they were actually paid. And again, it is our position that the court erred in granting those attorney fees.
Counsel, was there an objection made to Exhibit 19, which details the services rendered?
I think, but I can't remember. It's been a while. I made so many objections, but I think there was. And then the third assignment of error, we believe that based on the fact that the client could not get to Akron from Florida due to weather and COVID, the lack of flights, it was the first time requesting continuance that she should have been granted continuance, but we realized that continuance is in the sole discretion of the court. And those are our arguments.
Thank you, counsel. You will have your full 5 minutes when we get to rebuttal time.
Sorry for sitting down, but I had back surgery.
Of course.
I'm Robert Milo. I'm the attorney for the appellees, Kobe and Casey Brown. And I'd like to go ahead and address the appellant's attorney's counsel, or the appellant's counsel, as to the assignments of error. As to the first assignment of error, the Ohio Revised Code section that he stated, 5307.25, it states that the costs and expenses of a partition action shall be equitably taxed by the trial court, but it does not require the costs and expenses to be equally taxed to the parties. In several of the cases that he cited in his appellant brief, the trial in Blakemore versus Blakemore, trial court's judgment cannot be disturbed on appeal absent a showing that the trial court abused its discretion. term abuse of discretion connotes that it's more than an error of law or judgment. It implies the court's attitude is unreasonable, arbitrary, or unconscionable. Skipping down to Motorist Mutual Insurance Company versus Brandenburg, a Supreme Court case from 1995. The Supreme Court stated the issue in this case is whether the trial court abused its discretion in awarding attorney fees to the appellants. For the reasons that follow, we find the trial court did not abuse its discretion, and accordingly we reverse the judgment of the Court of Appeals. This court reaffirmed that in Ohio, an award of attorney fees must be predicated either on a statutory authorization or upon a finding of conduct which amounts to bad faith. Black's Law Dictionary defines bad faith as a conscious doing of a wrong because of dishonest purpose or moral obliquity. The appellant's purpose in this case was to deny the appellee's right to benefit from receipt of their father's estate by delaying whenever possible the appellee's right to receive their inheritance. The certificate of transfer was issued on May 6, 2020, and on May 18, 2020, the certificate was filed for record. On May 30th, the appellee's attorney notified the appellant that the appellees now own half the subject property, and they spent the next 5 months attempting to get the appellee to work out some kind of arrangement to sell the property or someone to buy the other one out. There was no response, and then it became necessary to file this partition. The appellant's son, Sergio Myrix, has lived in the property throughout this entire case. And again, we're coming up on 3 years. This May will be 3 years since the property was transferred into the name of the appellees. The appellant denied the appellees any access to the property or any payment for the appellee's son to use the property. When the property was to be appraised by agreement of the parties, it was in March of 2021, the appellant's son refused to allow the appraiser any access to the property. So we had to go back to court and set up another date for the appellee's attorney or the appellee's appraiser to look at the property. There's been a series of non-cooperation throughout this whole case, and it's our opinion that constitutes bad faith on the part of the appellant. Trial exhibit number 1 was a certified appellant's trial exhibit, appellee's trial exhibit number 1, was a certified probate court docket from the appellant's brother's estate that was filed, and it shows that the appellant filed no claim against the estate of her brother. Further, the appellant, between the dates of August 11, 2021 and 9/8 of 2021, did not respond to the appellee's interrogatories, which required the appellee's attorney to spend more time dealing with the court trying to get the interrogatories answered, which actually were never completely answered. The appellant's son, Sergio Myrix, in the trial transcript, filed for a civil protection order against the appellee's mother because she placed a 3-day notice on the door of the property. So even though it doesn't have directly to do with the partition case, it was again a delay issue where she had to go to answer to the Summit County Domestic Court, and the civil protection order was denied. And also the domestic the magistrate found that Sergio Myrix was in fact a tenant or a squatter on the property. So it was a verification by that magistrate that he was in fact living there. Basically, it's the appellee's contention that the various delays, of which there were many, and noncompliance with court orders constituted bad faith on the part of the appellant in this case, which according to the Supreme Court in Motors Mutual versus Brandenburg would allow the trial court to predicate the equitable awarding of attorney fees based in part on the appellant's bad faith. The trial court issued a case management order that was docketed on May 13, 2021. And of course, they put forth the schedule, the trial briefs, witness list of evidence exhibits shall be filed 14 days prior to trial. And if they're not filed, then the witness or the exhibit would not be admitted. The appellees filed all of our trial briefs, our witness list, our exhibit list, and all of our exhibits on December 20th, 2021, which was 2 weeks prior to the trial, so we completely complied with that order. The appellant and her legal counsel provided none of the documents prior to or at trial, and in fact, the appellant did not even attend the trial. So we were in full compliance, and the appellant was not. In regard to the appellant's assignment of error number 2 regarding the legal bill, the appellee's trial exhibit 19 is a very detailed legal bill. I prepare all my bills that way. The bill indicates what services were rendered, when they were rendered, and the time, intensive, and hours spent rendering the services. The legal hourly rate of $250 per hour was a reasonable and average hourly rate charged in the Akron area at that time. The legal bill was filed in the clerk's office along with all of the appellee's 20 trial exhibits on 12/20/2021, 2 weeks prior to the final trial. The appellant's attorney had complete access to all the appellee's trial exhibits in their entirety for 2 weeks prior to the trial, including the legal bill and including the non-legal, non-legal issues that were presented in trial exhibit number 20, the non-attorney fees. The bill contains a certification by Attorney Mihaila that the charges are a true and accurate bill. According to the trial transcript, page 38, line 25 through page 39, line 24, the appellant's attorney, Tyler, did not object on direct examination of Marcy Lynn Akers as to the admittance of the appellee's trial exhibit 19, the legal bill, and trial exhibit 20, the non-attorney expenses. Furthermore, the appellant's attorney did not raise the issue or question the validity of appellee's trial exhibit 19 or 20 on his cross-examination of witness Marcy Lynn Akers, the appellee's mother, in trial transcript, page 40, line 12 through page 42, line 15. Based on that, the court issued its ruling, and they returned to chambers, met, and included a reduction of $875 in the amount of attorney fees requested. During his opening statement on page 17, line 5 through line 22 of the trial transcript, Attorney Tyler states, "It's not our case. I have nothing to present today." Basically, the appellants treated this case as this partition case as though it was all the appellee's responsibility. The only thing that they contributed to it was to delay or not comply with court orders, which increased the cost of the legal bill, because this matter could have easily been resolved when the appellant was notified that her niece and nephew received half of the property. There were several options at that time to list it for sale with the real estate agent for one to buy the other one out. But there was no response and no cooperation, which again, I considered bad faith. It's within the equitable discretion of the trial court to assess which party has received the benefit during this partition action, which party had to expend time and funds to bring this matter to a conclusion while not receiving any benefit therefrom, and to make an equitable award accordingly, which is what the trial court did. They heard the evidence, they saw the delays and the noncompliance, and realized that it increased the legal bill significantly, and they made their award accordingly. And again, the appellant did not object or ask the court to allow him to question me about the bill at the trial. As far as the appellant's assignment of error number 3, on the trial transcript, page 4, line 2, through page 7, line 7, the trial court clearly stated their valid reasons for denying the appellant's request for a continuance. The appellant had enough time to arrange her appearance at the trial. There were options for her to travel other than airline travel to attend the trial. There was no proof offered by the appellant that she even booked an air flight to Akron for the January 5th date. The trial court stated on transcript, page 7, lines 5 through 6, quote, the court said, she, the appellant, had notice since May 2021 to be here today, and was not. The continuance was properly denied. How much time do I have? I can't see the clock.
You have 1 minute and 40 seconds.
Okay, thank you. There were 2 issues that I brought to the appeal, the appellee's brief. They had to do with non-admission of 2 exhibits that I had, but I don't consider those critical to the finding in this particular case. So our basic conclusion is that we basically agree with the trial court's final order from February 1, 2022, and we respectfully ask the Court of Appeals to affirm the trial court's decision in order on said date. And if the court would decide to, for some reason, to send this case back to the trial court, my chief and only witness has serious medical problems, which she's receiving chemotherapy for now, and I seriously doubt whether she's going to be able to go to any further trials, and I thought I'd better just mention that to the court. That would conclude my presentation.
Thank you, counsel. And you will have 5 minutes for rebuttal.
Thank you. While it is nice of appellee counsel to give reasons why the court could have awarded those fees, what the law requires for the judge to have put in her order while those fees were awarded. She did not do that. The revised Code 5307 says unless the services rendered by counsel seeking the fees are rendered for the common benefit of all the parties. There again was no evidence or testimony to suggest that. As relate to the attorney fees and the questioning, it was upon the attorney who's seeking these fees to make sure the amount of evidence to support the fees is put on the record. He said, I didn't do anything, it wasn't my job. The law requires those of us who require attorney fees to make sure that it's documented on the record that they are reasonable fees. That's why most attorneys, even in divorce cases, they put as a witness themselves because they know it's their job to show that the fees were reasonable and they were charged in the course of the action.
Isn't partition by its nature beneficial to both parties concerned? So the person incurring most of the legal fees is actually benefiting both parties because partition is necessary?
Well, I'm not sure, and I think that's why the revised code in the case law says it's the duty of the attorney to put that out there. I don't think that it's intended for us to make that assumption, but as with every case, the evidence needs to be brought before the court. So it's an assumption that we can make, but I don't think the law or the revised code support us making that kind of assumption. At trial, counsel for the plaintiffs asked Marcy Lynn Akers, what is the plaintiff exhibit 19? Transcript page 38, paragraph 25. Marcy Lynn Akers responded, these are attorney legal bills. Counsel asked, for what? Akers responded, representing the plaintiff, us. She was not a party to this case. Her adult children were the parties. So no party, not only my client, but no party to the petition testified. Her adult children did not testify that this attorney represented them at all, that these fees represented what he did for them. He brought his assistant, whoever she is, to him to testify, but the adult children who are parties of this case never testified that this guy billed them anything and that they paid for those services.
But she was the guardian of the minor children
When it was filed.
When the legal services were incurred.
Well, some of them, because by the time we got to trial, they were both adults. So she was the guardian when it started, but not the whole time and not when we got to trial. Although RC 5307.25 permits the trial court to award reasonable attorney fees, the statute requires the trial court, in doing so, to have regard to the interests of the parties. The benefit each may be derived from the petition and according to equity. This of necessity requires the objecting party be given notice and opportunity to be heard. This court addressed an award of attorney fees pursuant to RC 5307.25. Statutory provision for the allowance of reasonable attorney fees means that reasonable attorney fees shall be based upon the actual services performed by the attorney and upon the reasonable value of those services. Again, there was no testimony about what actual service was provided. What she said, these are legal bills. For what? What was performed? The burden is upon, in this case law, the attorney rendering the service which he is to be compensated to introduce into the record sufficient evidence of the service performed to justify reasonable attorney fees in the amount awarded. Where judicial determination is required to fix the amount to be paid, determining factor in the reasonable value of the attorney services, this determination cannot be arrived at in a controverted case solely by the application of a predetermined total percentage of appraised value of proceeds of sale. Further, in a controverted case, to deny to those defendants from those asset compensation will be deducted and paid. So again, it was his burden to put in the record that these services was rendered as related to the petition and to nothing else. That did not happen. He depended on a non-party to help him establish his fees, and I think he failed to do that, and I think it was an error of the court to grant those attorney fees in this petition.
Thank you, Ken. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it is released, and it will be posted on the Ohio Supreme Court website. Thank you very much.